Well, hi, everyone. I am coming to you actually having just completed office hours and had an opportunity to meet with some students via Zoom on office hours. And I know that you are going through the process of trying to kind of wrap your head around the concept of law known as torts. And with this session, I thought that I would not use any lecture slides. I would just talk to you about torts and ask you perhaps that you just listen and not necessarily try to take down everything that I'm saying in notes. In fact, I was thinking just the other day about one of my first years of law school, which is hard for me to believe, but 35 years ago. And we had a large classroom, and this is pre computer days. I was trying to just feverishly take down everything that the instructor was speaking about, and I happened to just look up during the lecture, and a friend of mine across the way had his pencil stuck in his chin, and he was just leaning on it on the desk, and he wasn't taking any notes. And this friend of mine ended up going on and getting the highest score on the bar exam the year that we took the bar exam. While I was trying to write everything down, he was actually just trying to listen and learn and retain the material. And I do think sometimes that we can get lost, the forest for the trees. And so I thought I'd take a moment and get away from the wording and the explanation and the definitions within tort law and just talk to you for a few minutes about this concept of law and try to help what is the most subjective concepts of law hopefully make a little bit more sense to you. You've heard me say this before. You'll probably hear me say this again, but we put a label or a definition on a concept, and we seem to make it seem more complicated than it really is. And so let me talk about tort law and try to back away from some of the labels and help, if I can, make this concept of law seem and make a little bit more sense. This is not, by the way, the exam review. I just think it's a bit of a necessary wrap up to this area of law. By the way, most of you are really doing quite well, even in this format of the class. And I'm optimistic that you'll do well on the upcoming tort exam, and I think that if you do, I think you'll find that property law principles, which we'll tackle next, is the most objective and very much more manageable area of law. But the idea behind tort liability and tort law is to hold people accountable for their behavior when, as a society, we would have expected from them better behavior. We've looked at substantive law in the establishment of responsibility, duty, through statutes that are enacted, through contracts that we voluntarily enter into. But now we look at it in the line of sight of when someone doesn't have a contract or there is no statute that mandates behavior. Are they off the hook, or are we not going to hold them responsible when, as a member of society, we expect from them a certain level of care? And this is consistent with tort liability. And it's really, except where it's not, it's really a fault-based concept. Those who are at fault for causing harm to others should compensate those whom they harm as a result of their behavior that dips below that which as a society we deem to be acceptable. And this is where it can become so subjective, because it's constantly subject to revision and review and updating and looking at things differently. We look at things differently now in light of the pandemic. We look at things differently when we see harm that has occurred that we, in retrospect, think was preventable. And we try to mandate that there be necessary changes so that in the future, that same harm will not happen. Next year, Mun Arena will celebrate its 50th anniversary. I happened to attend the very first game that was played at Mun Arena. It was the Detroit Red Wings hosting the St. Louis Blues, of your hockey fans. And I can tell you, having been in that arena, that there was no netting at all surrounding and protecting the stands from pucks flying up and striking patrons that were watching games. Watched many games through the years, and for a long period of time, no netting. Pucks flew up and people got hit. And then all of a sudden, somebody recognized, this is preventable. We could actually put our patrons in a position where they are safer by just actually placing netting around the ice facility. And that's the way the facility presents now 50 years later. We certainly see this with so many aspects of human life. The vehicles that you drive these days are far safer than the vehicles that I grew up driving. Some of this is mandated by statute. Some of this is mandated by regulation. Some of this is mandated by the producers of vehicles recognizing that families, and particularly parents of families, look at safety standards and make decisions on what to purchase based upon those safety standards. And some of this is brought about by lawsuits that are filed when people are harmed and the harm was preventable. And so what we try to do with tort law is we try to mandate those who are best in a position to minimize the likelihood of harm to others to act in a manner that is consistent with what would be reasonable in the eyes of most. Not necessarily what could have been done differently, but what should have been done differently. And so I've presented to you tort law as it is taught in law school. I have presented to you tort law as being divided into three different categories: intentional wrongs, negligent wrongs, and strict liability torts. But I share with you that when you, in life, are confronted with issues of tort liability, they are almost always negligent based. What constitutes the tort of negligence? I do think that it is important for you to look at the lecture slide that I uploaded that carries with it what I refer to as the spectrum of fault, because this is noteworthy that the more intentionally bad the wrong that is committed, the less actually we require a plaintiff show by way of harm. We don't make the victim of an intentional act show much, if anything, by way of how that intentional act has harmed the victim. Whereas when the harm occurs not through intentional wrong, but through unreasonable behavior, an accident, negligence, we do require that the victim show objective evidence of harm. And so I spent most of the time in the overview of torts with you focusing in on the law of negligence. And what constitutes negligent behavior, or another way of saying it, what constitutes unreasonable behavior, is something to which through the common law, we have placed certain parameters around. And those are the elements that need be established for the tort of negligence to be found existing. The elements for the tort of negligence to exist are that the wrongdoer have actually owed a duty to the person who is alleging that they were harmed as a result of an act of negligence. Simply because there is an injury that was preventable doesn't necessarily mean that the person who could have prevented that injury has acted negligently. You heard me talk about, and it's important to recognize that there is a zone of danger. If I strike the vehicle while driving my vehicle, I strike the vehicle in front of me, it is certainly reasonable to expect that I owed an obligation, a duty to all of the occupants of that vehicle in front of me that I have struck. I owed a duty, I owed an obligation to all of those in the vehicle that I am driving. I owed a duty to all of the pedestrians and all of the bicyclists in the roadway where I am driving. And if any of those persons are harmed, any of the pedestrians, any of the persons in my car, any of the persons in the car that I have struck, if any of those persons are harmed as a result of my negligent driving, my unreasonable driving, then I owed that person a duty. They're in the zone of danger. It is reasonably foreseeable that my conduct would likely put them in harm's way, at risk. And that's how we view duty. Is it reasonably foreseeable that my bad behavior could cause you harm? If so, then I owe you a duty, a standard of care, an obligation to act in a certain way to try to safeguard you from harm. Let's say that the person who I harm in the vehicle ahead of me that I negligently strike with my car, let's say that that person is a surgeon on their way to a hospital to perform a very serious and delicate surgical procedure. And because I have hurt that surgeon through my negligence, that surgeon is unable to perform surgery and the patient dies. But for my negligent driving, that patient very likely might not have died. But it is not reasonably foreseeable that my negligent driving would cause someone in a hospital miles away to die. That is beyond the scope of individuals whom I owe a duty when I am driving my vehicle. The duty is owed to the occupants of my car, the occupants of the cars on the roadways that I'm driving, the pedestrians on those roadways. It doesn't extend beyond those individuals. And so we try to put some guardrails. We try to put some elements to this concept of negligence to allow for a reasonable legal analysis as to when and when not to hold someone responsible for the tort of negligence. And the first element that we talked about was duty, this standard of care, this obligation that is owed, and whether or not it exists under a particular set of circumstances, under a particular set of facts. Obviously, what makes all tort law a little bit more complicated is when we're trying to determine fault, we already know the outcome. We already know that there has been injury. We already know that there has been damage, and we're trying to determine who should be responsible. These elements help us make that determination. The second element of the tort of negligence is that there was a breach of duty. This is that question that we present to jurors as to what should have been done under a particular set of circumstances. What would a reasonable person have done? What would a reasonable manufacturer have done? What would a reasonable design of the product have been? We don't expect or demand perfection. We expect that conduct will occur in a manner that is consistent with how a reasonably prudent person or business would act under the same or similar circumstances. That's a really subjective concept, but it should make logical sense. Not what could have been done, but what should have been done. Of course, there has to be a cause and effect relationship between the bad that occurred and the unreasonable conduct. That's the causation element. And because within negligence, the question is fault. There does have to be damage. Whereas within intentional torts, we minimize the significance of the damage element in determining if there is a case. Ours is a fault-based system. There are some, again, other rules that are applied. One of those rules, you may recall it as the eggshell-skulled plaintiff rule. And all that simply means is that we take our victims as we find them. The fact that you acted in a negligent manner and you caused harm to the one person that would be harmed by your behavior, whereas most of society would not have been harmed by your behavior, that's just bad luck. You found the wrong person as the victim of your unreasonable behavior, and you're on the hook for the totality of the harm that you have caused that person. That is the eggshell skull plaintiff rule. You don't have to necessarily foresee the type of injury that they would sustain. You have to foresee that they could be injured by your unreasonable conduct. You owed a duty, that duty was breached, the harm, while not what was expected, occurred, negligence follows. We apply the doctrine of comparative fault, comparative negligence. This also, take away the terminology, take away the definition, should make logical sense. When something bad has happened and we present the facts to the jury, we ask the jury to apportion responsibility. Person A acted negligently, so says person B. Person B probably is somewhat responsible for his or her own accident, but person A is absolutely responsible for what happened to person B. We will ask a jury to determine how much of the accident is because of the conduct of person A and how much of the conduct is because of person B. This is comparative fault, and when a plaintiff recovers from a claim of negligence and is awarded money, we'll actually reduce the award by the percentage that a jury says the plaintiff was at fault for their own accident. This is actually a very fair legal doctrine when you compare it to what was the previous legal doctrine that we utilized in the United States, and that was called the doctrine of contributory fault, that if a plaintiff was at all responsible for his or her own accident, they couldn't recover at all. This was a bar from recovery. You probably struggle a bit with the concept of strict liability. First of all, rarely does the concept of strict liability apply. When it does apply, it is the best recovery under the law of torts that a plaintiff can have, because you just bypass any determination of fault and you go right to a determination as what the damages should be. The idea behind strict liability is that there are certain circumstances in life that it's impossible to guard against the occurrence of those circumstances. It's impossible to insure against certain events. And when, in particular, a business engages in an ultra hazardous activity, when a business engages in producing, delivering product that is very, very dangerous, perhaps very combustible, bad things can happen without actually anyone necessarily being at fault. So what we do in those circumstances is we say to the business that is involved in an ultra hazardous activity, you are then de facto the insurer for all those who are injured as a result of your business model, the business that you have chosen to be in. Make sure that you have profited sufficiently enough that when something bad does inevitably happen, that you've got enough resources to actually compensate those who are harmed without any determination of fault. One of the other, I think, areas that people can struggle with within this concept of tort liability is when we, by statute, remove fault considerations from how we go about paying when something bad has happened. And what I'm thinking about now is workers' compensation and states like Michigan who apply the no-fault scheme. And in approaching an understanding of workers' compensation and no fault, again, I think it's important to hearken back to understanding that in the American legal process, when something bad happens, when we go to court because there's a plaintiff who alleges that a defendant has harmed them, this is ultimately about a recovery of money. That's what civil lawsuits are about overwhelmingly the majority of time. And we take this concept of money and we separated it really into two categories. Economic damages, money that is paid for loss that can be determined with certainty. Medical bills, lost wages, the fixing of a car, replacement services. Here's the bill. This is what it cost. Make the person who is at fault pay. And then the second category, non-economic damages. Money that is designed to compensate or intended to compensate for losses that cannot be calculated with certainty, notably pain and suffering. So if we look at recovery of money when there has been an accident, and we recognize that there are the possibilities of economic and non-economic damages, as a society, we have decided we're going to take workplace injuries, and in a no-fault state like Michigan, injuries resulting as a result of an automobile accident, and we're going to treat these separately. We're going to treat these differently. Workers' compensation. In sum, employees, those who are working on behalf of an employer, have insurance policies paid for by the employer to cover injuries that can be sustained by the employee while working. In fact, there are exceptions. I'm self-employed. I don't have a workers' compensation policy that covers me as a lawyer. That's an exception. But the rule is that employers are mandated to have a workers' compensation insurance policy to cover employees. Some employers, General Motors comes to mind, are large enough that they can be self-employed. But when an injury occurs within the working environment, a traumatic event that has happened, perhaps an injury that is sustained over a period of time through repetitive action, if the injury can be tied to work, if the allegation is that because of my work, this is the injury that I have sustained, then the workers' compensation system becomes the exclusive remedy for the injured worker seeking compensation from the employer. And it's not a fault-based system, meaning you don't have to prove that the employer did something negligent or wrong. You have to establish that there was the injury, and this will entitle the worker to benefits. But because of the, if you will, trade-off that is made with the insurance industry, the benefits that the injured employee is entitled to receive will be limited to economic damages. We don't award, again, there are always some minor exceptions in catastrophic events, but we don't award pain and suffering to those who are injured as a result of a work activity. The workers' compensation structure is established to pay economic damages, and even there, when it comes to, say, things like lost wages, a percentage of those lost wages, a little bit of an incentive perhaps to get somebody to go back to work. Similarly, in a state like Michigan that has adopted the no-fault statute, when there is a loss sustained as a result of a motor vehicle event, we have the parties to that accident turn to their own insurance carriers for payment of economic damages. I run into the back of your car. I am at fault. I do tremendous damage to your vehicle. You turn to your insurance carrier, and I turn to my insurance carrier for purposes of economic damages. To the extent that you have sustained significant damage to your car, it's paid for by your insurance carrier if you have coverage that covers you for those types of events. It's not on me, and it's not on my insurance carrier. We do not litigate fault for purposes of payment of economic damages. Parties turn to their own insurance. That's ergo why we call it no-fault insurance. Your rates go up. That's unfortunate because it wasn't your fault. That's no fault. We make the trade-off of getting immediate payment to those who have sustained loss, but we limit that payment to economic damages. Now, what we do permit is we do permit the victim, the party that has sustained serious injury, to seek non-economic damages, seek pain and suffering from the at-fault party, the driver that was responsible, the driver that was at fault, but only if the injured party can meet a certain threshold of injury to allow for a negligence determination to follow. And the threshold, and I talked about this in the no fault lecture, is death, serious and permanent impairment of an important body function, or permanent disfigurement. And the court will actually have to determine, has the threshold been met? If so, then we will allow for a determination of fault and a conclusion as to what non-economic damages, what pain and suffering should be paid by the at-fault party or their insurance carrier to the victim within the accident. These are what we refer to typically as third-party claims. I think it's important for you to have a working knowledge of this area of law. I will tell you that when I examine on this, the most that you'll get from me is what are the threshold injuries that permit a negligence determination in an automobile accident case in a state like Michigan that follows the no-fault scheme. What I'm getting at is that this is a fault-based concept, tort law, that has logic behind it. Those who are at fault should pay for the harm that they cause, hopefully motivating businesses and individuals to act with reasonable care, to not be at fault, to minimize the likelihood of harm and accidents. What makes it difficult, I know, is but if, but then, but when, you know, kind of the offshoots, the exceptions. Governmental immunity. If you're going to sue the government, you have to have the permission, the authority to sue the government by statute enacted by the government. The exceptions to fault-based liability. Strict liability, in tort, workers' comp, no fault. Don't lose the forest for the trees. Don't lose the big picture by focusing too much on these exceptions. Know that these exceptions exist, but don't fear these exceptions either. understand really what the purpose and objective of tort law is, and be able to look at a particular set of facts and in particular place those facts into, is this a intentional tort case? Is this defamation, a false, harmful statement about a person made to another, where we don't require the victim to establish much, if any, actual evidence of harm, because it's defined as an intentional tort if the victim is a private party, private individual, rather than a public figure. Is this a negligent claim where there has to be objective evidence of harm? Is the damages something that are physical, or is it to property, where we will certainly still allow for compensation of damages for losses sustained to property? And then lastly, is there direct culpability, direct liability? Are you claiming that the negligence is the person who has acted unlawfully? Or is this an attempt to hold someone responsible for the actions of, say, their agent? Imputed liability is what we refer to as when we hold an employer responsible for the bad acts of an employee. We impute liability in certain circumstances. I lend you my car, you drive negligently, you cause harm. That liability that you have engaged in can be imputed onto me by statute as the owner of the vehicle. But typically when we think of imputed liability, we think about an employer being responsible for the bad behavior of an employee, the negligence of an employee. Please note, and this is important, the employee, the bad actor, the negligent party is always responsible for their acts of negligence. The question is, can we also hold someone else, the employer, responsible for those actions? Frolic and detour. Many questions have been posed by you on the concept of frolic and detour. I ask you this question: what employer ever tells employees, go act negligently today? What employer would ever say to an employee, today and today only, I want you to throw caution to the wind and I want you to just act as negligently as you would like? Therein lies the reason we have frolic and detour. All defense attorneys would always point a finger at an employee and say, you can't hold the employer responsible. It was the employee that acted negligently. The employee did exactly contrary to what the employee was told to do. Frolic and detour come in to put a little bit of justice behind, I think, what defense attorneys would try to do in circumstances of where imputed liability should apply. If the employee is on a minor departure from what he or she or they should be doing as an employee, we will refer to this as a detour, and we will hold the employer responsible as well as the employee for the employee's negligence. A minor departure, a minor deviation. The employee wasn't doing exactly what the employee was supposed to be doing, obviously. There is negligence, there is harm, and the employee is going to be responsible. But the employee was acting on behalf of the employer, and this was a minor departure, a detour, if you will, from the scope of the employment, and we will impute liability. But if you have an employee that's involved in a major departure from what he or she or they are supposed to be doing, we, under the law, constitute this as a frolic, an out-and-out departure from the scope of what the job was supposed to be, and we do not impute liability in those circumstances. That's frolic and detour. Again, a classic example of labels that make a concept more complicated than it really need be. Law is supposed to get us to the right outcome. Law is supposed to promote the just result. Don't lose sight of that because you get into concepts that you've not heard of before, that may appear to be more complicated than they really are. This is why I thought as we get to the end of our discussion of torts, I ought to just take one moment without lecture to try to establish for you some context. Ethics game is coming to an end. Please finish that up. Writing assignment 2 will drop for you as soon as I complete writing it. The lectures will pick up a bit because unlike with tort law and exam 2, where it's, one substantive area for the exam, when we start moving forward, we're going to see multiple topics covered on exams 3 and 4. I think tort law is the most subjective, and I think sometimes the most difficult for students. And so I try to put a little bit less content together for exam number 2 as we get into some of the areas that I think are a little bit easier. Property law, business associations, employment law. You're going to see the topic list on the exams grow. And my attempt is to try to have equal difficulty on each of the 4 exams for you. And so you get a little bit less with exam number 2, but you're going to see it kind of pick up a little bit with exams 3 and 4 and the material coming up for exams 3 and 4. Not a better place to be, my opinion, than East Lansing, Michigan in October, even heading into November. Take some time to enjoy it. Big mistake that I made when I was a student is, I think, not taking enough time to enjoy the campus. I hope that you won't make that mistake. Sometimes you just got to put the book down, close the laptop, and just take a nice stroll across what is a gorgeous, gorgeous campus. Your mental health is something that you need to focus on. And it can be difficult and challenging, particularly when you get to the midway point in any semester. This is why I impress upon you, get some sleep. You'll perform better when you're rested. You'll approach things with a little bit less angst when you're rested. I am here for you. The faculty is here for you. Let us know how we can help. I will be posting a review and let me assist you as we get ready for this second exam. And as always, go green.